is Renee Carlson. I serve as General Counsel for True North Legal and the Minnesota Family Council. Female sports are a remarkable American success story in Minnesota and across the country. This is in large part due to the enactment of Title IX nearly 50 years ago. Title IX is historically recognized for breaking down barriers for women and girls by creating educational athletic opportunities just for them. Under this law, reasonable sex-based distinctions are not only permitted, they are required in order to carry out Title IX's distinct purpose. Minnesota followed by passing its own protections for women and girls, enacting what one Minnesota court called the counterpart to Title IX, including Minnesota rules referring to school athletic teams based on, quote, males and, quote, females in their categories. The federal government's executive order keeping men out of women's sports, and most significantly, federal courts have affirmed that Title IX prohibits discrimination on the basis of sex, not gender identity. In Tennessee versus Cardona, the case that vacated the Biden administration's interpretation of Title IX, the court explained that, quote, redefining sex to include gender identity contravenes the plain text of Title IX, which sought to level the playing field between men and women. Expanding the definition of discrimination to include gender identity would eviscerate the statute and render it largely meaningless. The Minnesota Human Rights Act embodies the same spirit and intent of Title IX in the exemptions relating to sex for both educational and private athletic teams. It even directs schools to comply with Minnesota's Title IX counterpart, conveying a common understanding of the law's intent and purpose, to create a level playing field for women in athletics while prohibiting discrimination against them. As the 11th Circuit held, a policy can lawfully classify on the basis of biological sex without unlawfully discriminating on the basis of transgender status. The Minnesota Attorney General and some Minnesota courts have twisted this exemption on its head. In an advisory opinion to the Minnesota State High School League, Minnesota Attorney General Keith Ellison stated President Trump's executive order prohibiting males from participating in female sports does not have the force of law and cannot supersede Minnesota state law, which was further explained by Leader Niska. Attorney General Ellison interprets Minnesota law to require the Minnesota State High School League, and by extension those districts which follow its policy, to require male athletes to compete on female teams. The U.S. Attorney General warned the league and Attorney General Ellison that state law does not override federal law, and perpetuating injustice against female athletes may result in lawsuits or termination of federal funding. Minnesota schools are now pitted between the loss of federal funding as a result of noncompliance with Title IX or losing opportunities for all of their student athletes. A number of school board members have already reached out to me asking for guidance, noting special concern about the requirements to certify yearly compliance with Title IX. The threat to women's and girls' progress is not limited to Minnesota educational institutions. It extends to athletic teams, youth sports organizations, and even businesses. A lawsuit is currently pending in the Minnesota Supreme Court where USA Powerlifting is being sued simply for restricting female categories to female-only athletes. Private athletic leagues are also concerned that they might be the next legal target. We are in receipt of an anonymous letter from a private athletic coach who's very concerned about this and the impact it will have on many girls playing in sports. Members, Minnesota laws that were enacted to protect women and girls in athletics are now being used against them. Athletic teams have long been separated by male and female in order to foster safety, fairness, and athletic opportunities for women and girls. At a bare minimum, this committee should ensure that no female athletic team or league will be subjected to unjustly lawsuits, penalties, investigations, or fines under Minnesota law simply for protecting women and girls' athletic opportunities consistent with federal law. House File 1233 is a step in the right direction. Thank you, members.